Well, welcome to this quick little Q&A on estate planning. I'm going to give you 5 things that you should do before you pass away. There was this client who was younger than I am, in his 40s, and he passed away now, but how it happened was his wife walked in and found him laying in bed. He was supposed to get up to go to work, and he wasn't moving. And so she was shaking him and he wasn't responding, and so she was obviously really concerned. Long story short is he had a stroke, and he didn't fully recover, and he did therapy for a while, but he wasn't able to go back to work. And so, but they were a younger couple, obviously, and they had expenses. They still had kids at home, and the house wasn't paid off, and so they had dipped into their savings, and she's really spending the money managing the household, and she's kind of nervous at this point because her husband has a medical issue that she is his primary caregiver. You know, when a spouse has a stroke, and it happens especially as we get older, where one spouse typically will start taking care of the other and so forth. Well, she didn't know if she was going to spend the next 20, 30 years taking care of him. I mean, they don't have enough money for that. And how are they going to qualify for government funds? But then a friend told her that, well, she needs to call the employer for her husband's retirement account and take the money out. It's a medical emergency. And of course, that's what she tried. But the financial people there told her that she couldn't. They wouldn't release funds. And come to find out, she's not an owner of the account. Well, it's an IRA, it's a 401k, it's an individual retirement account. Tax-deferred account can only be in one person's name, and she's not on it. Oh, what if she was the beneficiary? Then it'd be okay. Well, no, that doesn't work because he's not dead yet, right? He's still alive. So what do you do if you get sick, you have a prolonged illness, and your spouse or one of your adult children needs to take money out of the account to take care of you? Well, you have to do what's called a guardianship. You have to go to court and be appointed as the guardian, and so it's a delay, it takes more time, it takes more money. The whole point of this story is that you should do what's called a financial durable power of attorney. And that means that it can go into effect now, or it can be springing contingent upon your incapacity or illness determined by a spouse or a physician or something like that. All that can be put in place exactly the way you want it. But the point is, if he had filled this out and named his wife as his decision maker, that if medically something happens to him, then she would have been able to call the HR company and talk to the financial 401k account people, and they would have released funds. But, you know. And oh, by the way, is there going to be a penalty because you take it out early? I know. The government's going to penalize you. But sometimes you got to do what you got to do. But at least you can get your hands on the money. First thing you should do is financial stuff. Well, what about health care? What about just giving her the authority to make his healthcare decisions? We forgot to talk about that, right? I mean, that should be the very first thing, but most people just assume that because they're married that they automatically have a medical power of attorney for their spouse. You don't. Not after HIPAA. Yeah, you know, you can thank Obama for that, right? And the Health Insurance Portability and Accountability Act, that's always a tongue twister, right? HIPAA laws. You know, a lot of times they were just kind of selectively enforced, but most institutions, especially after COVID, that means you need to name a loved one to be your spokesperson for you if you are incapacitated, if you're in a car wreck, if you have dementia, if there's a stroke, right? And you want to probably have adult children as backups in case both of you are in a car wreck together. You definitely need that. You also want to make sure, like a living will, that you have do not resuscitate instructions and those kinds of things. Some people do want to be given every opportunity to fight for their life. Some people want to leave as soon as possible and not have a long strain on the family and rack up $10,000 a day in ICU or whatever. It's up to you. So you need to have all of that in place. So those are medical powers of attorney. Now, there was a law that was passed a couple of years ago. It was 2021. It was the Oklahoma Advanced Directive Act. So if you have an older living will, you may want to update it. A lot of older wills and even older trusts don't have the most current advanced directives. And why you want that is just for practical reasons. When you walk into a hospital and you're like, hey, you signed it, if it says living will, a lot of staff, because it says will, they're not lawyers and they only have a few minutes or a few seconds and they're busy. And they are going to have to kick that to the legal department of the hospital. They don't want to have to read through this 30-page document and make a decision. But if it's the advanced directive form, that's the one they're used to seeing, they can look at that, flip to page 2 and go, oh yeah, it's got your name, because their eyes are trained to the form that all the hospitals are trained to use now. So it's really important you have that updated form. So the number one thing to review is the financial, medical, durable power of attorney. The second thing would be the medical powers of attorney, and those could be physician's directives, advanced directives, do not resuscitates, living wills. We will take care of all of that in the medical powers. The third thing you should do is check the deeds to your properties, to your houses, to your land, to mineral interest and business interest. Deeds. Deeds are typically filed in the counties. Now, deeds are important because this is probably the number one way that people end up in probate, and they thought they were going to avoid probate, but they made a mistake. Like, there was a client and her husband was married years ago. Early on, his wife died in childbirth and they had 2 twins, and luckily his mother helped him out so much. And later on he did get married to the lady now, but she raised those girls, and those girls never knew the real mom. All they knew was their grandmother and their mom. That they call her their stepmom, mom. So she raised those girls, and he lived on the 20 acres in Claremore on their property. They were married for 40-something years. And she asked him, she's like, did you ever put me on the deed? And he's like, yeah, I put you on the deed. Well, he thought he did. You know, like a lot of guys, he filed a deed. He quit claimed to take his wife off and to put his new wife on. But when you fill out a deed, it has to say some things on it, but he didn't know that. And if it says to him and her as husband and wife, as joint tenants, he figured that sounded good, right? Well, it doesn't avoid probate in Oklahoma when he dies. Right? You didn't know that? Because it didn't define the type of joint tenancy. In Oklahoma, if you don't say with rights of survivorship, with the entire fee simple estate vesting in the survivor of us, then it is not deemed to have survivorship rights. It must be stated explicitly on the deed. Well, he didn't know that. Most people don't know that. Well, can you write, ROS, WR with rights of, no, you can't. Well, I thought if you wrote and or, then it doesn't work that way. I just told you, it has to say explicitly in words that the entire fee simple estate vests in the survivor, or there's no survivorship rights. Because in Oklahoma, it's defaults to tenants in common. Tenants in common, I think, is a carryover from the frontier days or whatever, and people would go out and they wanted proof that if they were going to homestead for so many years and they were going to get a land grant, that the house would literally be theirs and pass to their kids. If the government, gives them this deed, they don't want it to go back to the government, right? They want it to go to their kids. Well, the tenants in common idea is that when mom and pa pass away, it's evenly split 3 ways to the kids. So that's what it happens today. When you have a husband and wife as tenants in common, that means 50-50. So she only got half of it. She didn't get the whole property. So she had to probate the other half. But the problem was, who owns the property? Who really owns the other half? The girls, right? And they're not blood. Now, normally, that might not be such a bad deal because they'd have a pretty close relationship, except they didn't. One of the girls was older and moved to California and didn't have much contact. She wanted money. What is the value of land done recently? Yeah, it's gone up a lot. She wanted money. So can she force her mom to sell the property? Yeah. Now that doesn't seem right, does it? But that's the law. So it's really important that you get your deeds checked. I can look over a deed and probably tell you in 30 seconds if it's right. But then we got to make sure it's actually filed. A lot of people, they'll get a deed but they don't file it, or they don't file it right. So the deeds are probably the number one way that people end up in probates. Well, I heard that we can just do a TOD, transfer on death. Does that work? Well, It doesn't protect against bankruptcies and divorces and exes. There's a lot of things that can go wrong with that. Like, for example, we had a guy and he did construction, and it was, he just wanted to keep it simple. He had 2 kids, son and his daughter. His daughter was the one that actually helped him in the business. The son moved down to Dallas or someplace. He was an accountant, had his own life, his own wife. He wasn't estranged from his dad, he just wasn't involved in his dad's business. The business was a small construction company, and his daughter, she ran the books, she answered the phone, she did the email and all that kind of stuff. It was a good team. There wasn't a lot of money as he got older in the business bank account, but there was some in there. So he figured, you know what, I'll put her on the deed. I'll put her on the business bank account. That way, everything else will be split 50-50, but if something happens to me, I want my daughter to have a little bit more. So what happens if he's got this lake house and he wants to put the daughter on the deed to that? It's her kids anyway, the grandkids that come out to the lake with grandpa, so it kind of makes sense. The son will understand, right? Maybe, right? But what happens if he puts her on the deed and she gets in a car wreck? What happens if he puts her on the business bank account and she gets in a car wreck? Well, it's a business account. Yeah, but she's not a member of the business, right? So right now you basically have commingled an account. So if she gets sued because of a car wreck that was her fault, can they wipe out the business account? His business account? Yes, absolutely. What if her husband has a gambling problem? What if they filed for bankruptcy? Can they wipe out his business account? Yep. Can they take away the lake house or file a lien on it in bankruptcy court? Yep. What if there's some medical bills? Yep, same thing. I mean, you kind of see what's happening here. If she gets divorced, he's going to lose that lake house. If she gets divorced, the husband is going to take his bank account. Well, his name's not on it. No, but they're married. So you don't want to add your adult kids on deeds. You don't want to add your adult kids on bank accounts, because if they get in a car wreck, if they get divorced, if they get in a bankruptcy, if they have any of these problems, you could lose your money. You could lose your property. Now, let's say you're lucky and they don't get divorced, they don't go through bankruptcy, nothing bad happens, but she's going to get hit with a capital gains tax. Oh, we did it with Mom and Pa and nothing ever happened. That's because they didn't audit you. But now it's all computerized, and with the government watching everybody, the government knows if you add somebody on a deed, then they're going to get a notice from the IRS that says that they're responsible to pay some capital gains taxes on that property. If you had the lake house since 1980, what do you think it's worth now? It's probably gone from, say, $100,000 to $250,000, $300,000 in value. So let's say it's a $200,000 gain. What's 20% of $200,000? About $40,000 in taxes that the daughter has to pay. Now she's going to say, well, Dad, I don't have the money, so he's going to have to pay. He doesn't want to. Okay, why don't we avoid losing the property? Why don't we avoid the capital gains tax to the daughter and leave the property to her in trust? That will fix it. If you leave it in trust, then it will pass tax-free to the daughter. And if she gets divorced, if she goes through a bankruptcy, if there's a car accident, she won't lose it because we can make it a protected trust. What's a trust? A trust is this thing right here. So Oklahoma estate planning, and so there's different types of trust. Long story short is it's better than a will. It will solve you a lot of problems, but there's different types of trust. So even if you get your financial powers of attorney, even if you get your medical powers of attorney, even if you get your deeds to land in trust, right? Is it going to protect everything? Well, the fourth thing you have to do is decide how to protect the assets. You have to do asset protection. So some trust, and I would say probably 95% of trusts that I've seen in Oklahoma are revocable living trusts. They don't protect your property if you go into a nursing home. You didn't know that? Most people don't know that. But there are homestead protection trusts where you can stack two trusts together, right? Now, I actually do have a protected trust in here, so it's really just one booklet. But two trusts stacked on top of each other so that, think of it as like one avoiding probate and one protecting the house from Medicaid or the nursing home. And so you can put land in it too. So if you have ranch, I've got guys that have put, folks like Larry here, Anyway, my wife made this. This is like just a little scrapbook over the years of some of the clients. But anyway, I just was thinking about Larry because he's got a few acres, several hundred, right? And he wants that boy to get it. Well, that boy is now 50 years old, right? But, that's just kind of how Larry is. He's like, well, I want to make sure that boy actually gets it, not the government. Well, you need a protected trust then. So whether it's just a little old 3-bedroom, 2-bath house or whatever, or it's hundreds of acre ranch, Oklahoma has no limit as far as the protection trust, how big it is, which is great. Some states have a limit. So we're lucky that way. You need to do a revocable trust and a protection trust if you have extensive assets. So those are deeds, and those are asset protection. Okay, there's more I could say about protecting the money, but just to help keep this short, I'll save that for another video, and I'll give you a practical thing you should do. And that is, in today's world, in the modern world, you should write your passwords down. And I am not kidding. Write your passwords down. Even if it is a slip of paper, you can have a little notebook. I thought I had one here, but I don't. You can have a little notebook or a little slip of paper, and you can put it inside this. And then your passwords, because I can't tell you how many guys have walked in with a box of stuff. Their wife passed away. It's been a couple years, and they just haven't brought themselves to get rid of everything. But they got a box of stuff, and she did all that. She had the computer and the passwords and stuff. I can't even check her email, so I don't know. And it's just a big mess, and it's just getting worse and worse. You don't want that. So at least write down passwords to the email accounts and bank accounts and things like that, so your loved one would be able to help you. So let's review. You need your financial powers, you need your medical powers. The financial, I would do the durable power of attorney. The medical, I would also get the advanced directive done. The third thing is to do the deeds, to file the properties in trust so they avoid probate. The fourth thing to do is to protect the assets, to look at homestead protection trust so you don't run into the government or nursing homes or other things like that taking the money. And the fifth thing you should do is please write your passwords down. Don't rely on just it being saved in the browser of your computer that Google or whatever will remember the password. Don't do that. Just write them down. Okay? All right. So I'm Jeff Burritt, estate planning attorney. What you need to do now is you need to call our phone number and have a free phone call with me. That's the next step. That's what, don't procrastinate. Do you know that 60% of Americans die without a will? In today's world, 60% of Americans die without a will. It's because people procrastinate, so don't do that. It's going to be a problem. It's going to go to probate. It's going to be a big mess for your family. I didn't have time to tell you all the probate stories, but it's a mess, and it can cost thousands and thousands of dollars. You could have a huge tax burden upon your family, and you don't want their last memory of you is thanks Dad, thanks Mom for the big mess, for the big tax bill. So you can avoid that. And it'll give you peace of mind. So you know you were responsible, you got some important work done, and it feels great so that you can go on and live your life. And if there ever was a problem, well then you can call me and I can fix it for you. So call the number, let's set up a free phone call and talk about what you can do to protect you and your family in trust. Do that right now. Talk to the receptionist and get a phone call on my schedule so that we can do a quick Q&A so I can find out about you and your family and answer all your questions. And it's a free phone call, by the way. So go ahead and do that now. And I look forward to hearing from you really soon.